Good evening and welcome to Courts Today by Livelaw. This is your host Urvashi Chauhan bringing you the latest updates on the legal front. This is your go-to source for all things legal. Let us start. The famous dialogue Tareekh pe Tareekh by actor Sunny Deol in a 1993 film has been often used to denote prolonged delays in the justice system. In the film, it was expressed to show exasperation at the repeated adjournments in a case. Today, while requesting the members of the bar to not seek adjournments of matters unless very necessary, the CJI said that he did not want the Supreme Court to become a Tareekh pe Tareekh court. The CJI cited statistics showing that a significant number of adjournment requests and highlighted the inefficiency of the practice. There have been 3,688 adjournments in the past 2 months at the Supreme Court. The CJI further pointed out that there have been 2,361 cases mentioned for urgent listing in the court since September 2023, with an average of 59 cases mentioned daily. This has created a paradox where cases are initially listed quickly but then subsequently adjourned. The CJI has urged members of the bar to seek adjournments only when absolutely necessary, emphasizing the importance of preventing the court from becoming associated with prolonged delays. The Supreme Court bench comprising CJI Chandrachud, Justice J.B. Pardewala and Justice Manoj Mishra today heard the writ petition filed by Aam Aadmi Party leader Raghav Chadha, challenging his suspension from the Rajya Sabha during the monsoon session. He was suspended over the allegation that he did not ascertain the willingness of certain members whose names were proposed by him as members of the Select Committee for the GNCTD Amendment Bill. Contemplating a way forward in the matter, the Supreme Court today recorded the statement of Chadha agreeing to tender an unconditional apology to the chairperson of Rajya Sabha and urged the chairperson to take a sympathetic view for the same. In the last hearing, the bench had expressed concerns at the indefinite suspension of Chadha and had remarked that the principle of proportionality had to be kept in mind as exclusion of the voice of an opposition party was a serious matter. This matter is now listed after Diwali break. The Supreme Court today refused to interfere with the order passed by Allahabad High Court Chief Justice Pritinkar Divakar, transferring the cases concerning Kashi Vishwanath Gyanvapi mosque dispute to his bench from the bench of another judge. A bench comprising CJI Chandrachud, Justice J.B. Pardewala and Justice Manoj Mishra was hearing an SLP filed by Anjuman Intizamiya Masjid Committee, which manages the Gyanvapi mosque. It challenged the High Court Chief Justice's transfer order. The issue relates to petitions filed by the Masjid Committee challenging maintainability of suits filed by Hindu worshippers seeking right of worship in the Gyanvapi mosque. A bench of Justice Prakash Padya had completed hearing in the matter and was to pronounce the judgment on 25th August this year. However, on the very same day, the Chief Justice withdrew the matter from Justice Padya, citing the reason that the judge could not have retained the matter despite roster change. Chief Justice Divakar had received a complaint that after 35 hearings in the matter, Justice Padya reserved the judgment for the first time in March 2021. However, the judgment was not delivered for 7 months and the matter was again directed to be listed in October 2021. Then the case was heard for around 12 months and the judgment was reserved in November 2022. The matter was again listed in May this year and again the judgment was reserved in July. The Apex Court dismissed the SLP and refused to interfere with Justice Divakar's transfer order. It said that the order contained sufficient reasons justifying the transfer. Also in a related development, the Archaeological Survey of India has informed the Varanasi District Court that it has already completed its survey of the mosque premises and now its technical members are preparing a detailed report of the same. As you know, the ASI had been conducting a scientific survey of the Gyanvapi complex in Varanasi as per order of the Varanasi district judge to determine if the mosque was constructed over a pre-existing structure of a Hindu temple. The ASI has now been directed to submit its report by 17th November. The Supreme Court today expressed its reservations about directing the Union government to immediately implement the 160th Amendment Act, which proposes to introduce women's reservation in the Lok Sabha, the upper houses of the state legislatures, and the Delhi Legislative Assembly. Although the constitutional amendment was signed into law by the President in September this year, the Act will not be implemented until a delimitation exercise is conducted following the next census. A bench of Justices Sanjeev Khanna and S.V.N. Bhatti was hearing a PIL petition filed by Congress leader Jaya Thakur, claiming that this constitutional amendment, passed with overwhelming support in a special session called for the purpose, could not be withheld. The next update is regarding a Supreme Court judgment against which several petitions were filed seeking its review. I am referring to the judgment by a bench comprising Justice V. Ram Subramanian and Justice Pankaj Mittal, which in April this year held that allopathy doctors and doctors of indigenous medicine cannot be said to be performing equal work so as to be entitled to equal pay. The court had observed that by the very nature of the science that they practice, and with the advancement of science and modern medical technology, the emergency duty that allopathy doctors are capable of performing and the trauma care that they are capable of providing cannot be performed by Ayurveda doctors. Thus, they were certainly not performing equal work to be entitled to equal pay. Today, a bench comprising Justices Abhay S. Oak and Pankaj Mittal dismissed the review petitions filed against this judgment. The court said that there was no error apparent on the record and no ground for review. The Supreme Court today granted journalists Ravi Nair and Anand Mangnale interim protection from being arrested by the Gujarat police over an article they wrote about the Adani Hindenburg row. In January this year, after Hindenburg published its report accusing the Adani Group of widespread manipulations and malpractices to inflate its stock prices, Nair and Mangnale co-authored an article which was published on the website of the Organized Crime and Corruption Reporting Project. In October, Nair and Mangnale received notices from Ahmedabad's crime branch directing them to appear in person in connection with a preliminary inquiry being conducted on the strength of application by an investor. Today, a bench of Justices B.R. Gawai and Prashant Kumar Mishra was hearing writ petitions filed by them challenging the summons. Advocate Indira Jaisingh, appearing for both the journalists, pointed out that Nair and Mangnale had not been provided with copies of the application that the summons referred to. They were neither informed of the legal provisions invoked to issue the notices nor whether an FIR was pending against them. Moreover, when they wrote to the Ahmedabad crime branch seeking additional information, they were told that the documents sought would be provided when they appeared for questioning. After hearing the senior counsel's submissions, the court issued notice on both pleas and also agreed to grant them interim protection from coercive action. The next update is on a writ petition filed in 2021 which raised concerns about misuse of mobile numbers after they are disconnected or deactivated. The Telecom Regulatory Authority of India informed the Supreme Court that once a cellular mobile telephone number is deactivated for non-usage or disconnected on the request of the subscriber, it is not allocated to a new subscriber for at least a period of 90 days. A bench of Justice Sanjeev Khanna and Justice S.V.N. Bhatti observed that it is for the earlier subscriber to take adequate steps to ensure that privacy is maintained. The court also said that a subscriber can prevent misuse of WhatsApp data by deleting their WhatsApp account attached with the previous phone number. WhatsApp informed the court that in case of recycled phone numbers, WhatsApp monitors account inactivity. When an account is inactive for 45 days and then the account is activated on a different mobile device, the old account data is removed. Recording these observations, the court disposed of the writ petition. National Law University and Judicial Academy Assam has taken a significant step towards promoting inclusivity and the well-being of its female students by implementing a menstrual leave policy. Under this new policy, female students at the university are now entitled to avail menstrual leave. To do so, they are required to submit an application, and these leave days will be in accordance with the institution's existing medical leave policies. Also, students must maintain a minimum attendance of 65% to be eligible for this leave. Notably, NLU Assam is not the only institution to implement such a policy. Dharamshastra National Law University, Jabalpur and Nalsar University of Law have also adopted similar measures in the past. The Kerala High Court today called upon the Kerala government and the Kerala Sports Council, that is KSC, to provide assistance to a young professional handball player who had been injured during the Junior Girls National Handball Championship. The young handball player, who belonged to a middle-class family, suffered from a ligament tear. She had approached the KSC for financial aid, stating her grievance that her future as a handball player would be jeopardized without the same. Her father had managed to give her the best medical assistance possible on earlier occasions, as she had previously undergone multiple reconstruction surgeries on her ligament, but now he was incapacitated from financing her further treatment. She averred that her representation before the KSC seeking financial aid had not brought forth any response. The court directed KSC to consider her representation and take a decision within a period of 2 weeks. Justice Devan Ramchandran also said that the state authorities ought to provide necessary assistance to sports professionals, since a vibrant society requires not just persons in academic and service pursuits, but also athletes and sports persons inculcated with a robust sporting culture. I hope you found this video informative and enjoyable. If you did, please consider giving it a thumbs up and sharing it with your friends. Don't forget to subscribe and hit that notification bell so you won't miss any of our future content. You can also support us by donating through the thanks button at the bottom of our videos, or consider becoming a member at just 89 rupees per month.